Most people ask an immigration consultant 2 questions before they hire them. How much does it cost and how long does it take? Those are the 2 least diagnostic questions you can ask. The price tells you what someone charges. It tells you almost nothing about whether they can do the work. The timeline gives you a number, and as I covered in the full timeline video, it routinely diverges from what the process actually delivers. The questions that tell you whether a consultant is actually competent and whether you're protected when things don't go smoothly are different. There are 7 of them. I run a company called Beyond, and we handle Netherlands immigration and company formation together. We work with non-EU founders on this process daily, which means I've sat on both sides of these conversations with people evaluating us and watching them describe consultants they previously worked with who hadn't given them a clear answer to any of the questions I'm about to cover. Use this list however works for you. Send it to any consultant you're evaluating. Why evaluation matters more than usual here. The BV plus HSM process has real consequences for wrong guidance. An incomplete recognized sponsor application triggers RVO requests that extend the timeline by months. Wrong DGA salary advice setting it to the tax minimum instead of the IND immigration threshold can result in permit revocation after you have already relocated. A rejection on the permit application means fees are gone. Time is gone and you start over. The HSM route via your own BV is a relatively specialized combination of company formation and immigration law. Not every consultant who handles Netherlands immigration has current working experience with recognized sponsor applications and HSM permit cases specifically. The case count tells you less than you think if it isn't the right type of case. These questions service that distinction. Question 1. What exactly is included in your fee and what specifically is excluded? This is where most scope surprises start. People hear a total, agree to it, and discover mid-process that several things they assumed were included aren't. A complete answer covers at minimum whether the RVO facilitator assessment is within scope or a separate cost, whether the IND government application fee is included or billed on top, whether company formation is covered, whether year 1 accounting and compliance is within scope or a separate engagement, and separately what happens if the IND sends additional document requests, is responding to those included or additional billing. If the answer to what excluded seems short, ask again until you have an exhaustive list. Every item on the excluded list is a future invoice. I put together a full breakdown of every cost category in the process. The video is already on the channel and I will link it. And once you have that link, you can check each item explicitly against what any consultant includes or doesn't. Do you handle the recognized sponsor application, including the RVO assessment for the BV, or is that a separate cost or engagement? The BV plus HSM process has 2 distinct parts. Getting the BV recognized sponsor status, which may involve an RVO assessment for a new BV, and the HSM permit application itself. Some providers handle both in-house, one scope, one relation. Many handle only the permit side and leave the recognized sponsor application to another party. Neither model is inherently better, but the answer changes how many service relationships you're managing, who is responsible for coordination, and when there is a problem and how the billing is divided. If they hand off the recognized sponsor work as 2 handles it, whether you will have direct communication with that party, and how the 2 scopes are coordinated, the RVO assessment takes longer than expected or needs revision. The handoff between the recognized sponsor process and the permit application is where timeline problems most commonly compound. How many BV plus HSM cases have you handled in the last 12 months, and what were the outcomes of the recognized sponsor application? This is the question that separates active practitioners from people who know the process theoretically. A consultant working the BV plus HSM route regularly will have a concrete number for recent cases. They will know what the RVO is currently asking for. In recognized sponsor assessments for new BVs, which BV structures get through quickly and which trigger revision requests, and how the IND is processing HSM applications right now. They will be able to describe recent outcomes not as a headline figure, but with some sense of what those cases actually involve. Ask specifically for the last 12 months. If the answer is a number with context, we submitted X recognized sponsor applications. I were approved without revision. Here is a type of case that needed extra work. That's a consultant with current working knowledge. If the answer is we're very experienced or we have a high success rate, without specifics, press for the number. Fake answers to a specific question or relevant information. Does it sound familiar? Leave a comment below. What happens if the IND sends additional document requests? Is that within scope or additional billing? IND document requests during processing are common. When the IND requests additional materials, the official clock resets or extends. Responding requires gathering documents, preparing submissions, and communicating with the IND on the application. Some consultants include this in scope, others treat each request Round is additional billable work. Over a 4 to 6 month process, 1 or 2 additional requests. Sounds can mean several €100 in unplanned fees. The question to ask: what's your approach when the IND requests additional documents? Is that included in the engagement, or do you bill for it? If they bill for it, how is that scoped and what's a realistic estimate? What happens if the application is rejected? This is the risk question. It gets skipped because it's uncomfortable to raise before the process has started, and some consultants are happy to let it slide. But a rejected application is a real outcome. The IND application fee is non-refundable. Time spent is not recoverable. Depending on the scope arrangement, you may owe fees on top of what you have already paid. And you're back to the beginning. What to ask: is there any review or appeal process included in scope if the application is rejected? What does the consultant do practically when an application doesn't succeed? Have they had applications rejected, and what happened next for those clients? Any consultant who has been running these cases has seen rejections. Their willingness to discuss this and the quality of the answer tells you something about accountability and about what the relationship looks like when the outcome is difficult. Question 6. What does a recognized sponsor application process looks like? Who prepares the RVO financial plan, and what is it and isn't in scope? For a new BV on a standard recognized sponsor track, the RVO assesses the company's business plan, organization structure, and financial forecast. Someone needs to prepare the financial plan documentation, and that's a specific piece of work that sits between accountant scope and immigration consultant scope. Some providers cover it, many don't. Ask specifically who prepares the financial forecast documents required for the recognized sponsor application. Is that within your scope, or is it an additional engagement with an accountant or third party? What is the expected timeline from BV formation to recognized sponsor status, and has your firm handled applications where the RVO requested provision or additional information? The video on the 2 DGA salary thresholds linked in the description gives you a concrete example of the kind of detail that separates a consultant with real working knowledge of this process from one who doesn't have it. Question 7. Who will be working on my case day to day, and how do I reach them? The person who sells you the engagement is often not the person who handles it. Senior consultants pitch, junior staff or paralegals manage the day-to-day. That's a normal service business model. The question is whether you know who your actual case handler is before you sign. The question to ask directly: who's responsible for my case, and what's their experience with BV plus HSM cases? What's the best channel to reach them when I have a question, and what's a realistic response time? A consultant who answers this with a name and a clear process has thought through client experience. A consultant who says, "we have a team that handles that," without specifics, hasn't thought it through and may not be easy to reach when you need a clear answer at a critical point in the process, like many consultants. How to use this list: send these questions to any consultant you're evaluating before your first paid conversation. How they answer matters as much as what they say. Specific and complete, that's what good looks like. Vague on multiple questions. That tells you something useful about how the rest of the engagement is likely to go. If you want to see what a complete BV plus HSM consultant scope should actually cover document by document, step by step, the HSM application checklist is in the description. Use it to check any proposal against what the process actually requires. The full cost breakdown is linked in the description, and the timeline video, which gives you the realistic picture of what you actually what happens from BV formation to residency, is also linked. Subscribe for weekly content on Netherlands immigration and business setup for non-EU entrepreneurs.